I was sitting in my home office in Scottsdale, Arizona, staring at my computer screen when the doorbell rang with an aggressive persistence that made my blood pressure spike. It was 3 in the afternoon on a Tuesday, and I had been in the middle of a crucial video conference with clients in Tokyo when my primary internet connection had suddenly dropped. Thank God for my backup satellite internet system, which had kicked in seamlessly and saved the presentation. The doorbell rang again, longer this time, and I could hear someone pounding on the door. My name is Yannick Emerson, and I have lived in the Sagaro Heights subdivision for exactly 8 months. I am a 34-year-old software consultant who works from home, which means reliable internet is not just a convenience for me, but an absolute necessity. When I bought this house, I made sure to install redundant internet systems because a single dropped connection could cost me thousands of dollars in lost contracts. I had my primary fiber optic connection through the local provider, and I had installed a satellite internet backup system that would automatically take over if the primary connection failed. I opened the door to find Brenda Patterson standing on my doorstep, her arms crossed over her chest, her face twisted into an expression of righteous indignation. Brenda was the president of the Sagaro Heights Homeowners Association, a 52-year-old woman with a blonde bob haircut that looked like it had been shellacked into place with an entire can of hairspray. She wore a white polo shirt with the HOA logo embroidered on it and khaki capri pants that screamed suburban authority figure. "Mr. Emerson," she said, her voice sharp enough to cut glass, "we need to talk about that monstrosity you have installed on your roof." I took a deep breath, trying to maintain my composure. "Hello, Brenda. What seems to be the problem?" "The problem," she said, stepping forward uninvited, "is that satellite dish on your roof. It is absolutely hideous and it violates our community aesthetic guidelines. I have received multiple complaints from your neighbors about how it is ruining the visual harmony of our neighborhood." I glanced past her at my front yard, then at the neighbors' houses. My satellite dish was a standard 18-inch unit, painted to match my roof tiles, and positioned on the back slope of my roof where it was barely visible from the street. "Brenda, that dish is on the back of my roof. You can hardly see it from anywhere in the neighborhood." "That is not the point," she snapped. "The point is that it is there, and it should not be. Our HOA covenants clearly state that no external antennas or satellite dishes are permitted without prior written approval from the Architectural Review Committee, and you never submitted an application." I felt my jaw tighten. I had actually read through the HOA covenants before installing the dish, and I had done my research on federal law specifically because I anticipated this exact confrontation. "Brenda, I am protected by the FCC's over the air reception devices rule, which was established in 1996. Federal law supersedes HOA regulations when it comes to satellite dishes that are 1 meter or less in diameter." Her eyes narrowed. "I do not care what some federal rule says. This is a private community and we have standards. You will remove that dish within 7 days, or we will fine you $100 per day until it is gone." "That is not legal," I said, keeping my voice level. The OTARD rule specifically prohibits HOAs from restricting the installation of devices used to receive video programming signals or fixed wireless internet services. My dish is used for backup internet access, which falls under that protection. Brenda's face was turning an alarming shade of red. "We will see about that. I am calling the authorities about your illegal installation. You cannot just do whatever you want and hide behind some obscure federal regulation." She turned on her heel and marched back to her white Lexus SUV, which was parked in front of my house with the engine still running. I watched her drive away, feeling a mixture of frustration and anxiety settling in my stomach. I knew I was legally in the right, but dealing with an HOA dispute was the last thing I needed when I was trying to manage a demanding work schedule. I went back inside and returned to my office, where I spent the next hour researching the OTARD rule more thoroughly. The FCC Regulation 47 CFR Section 1.4000 was crystal clear. It prohibited restrictions that impaired the installation, maintenance, or use of antennas used to receive video programming or to receive or transmit fixed wireless signals. The rule applied to devices that were 1 meter or approximately 40 inches in diameter or less. My 18-inch satellite dish was well within those parameters, and it was installed on property that I owned or had exclusive use of, which meant the HOA had no legal authority to make me remove it. I printed out copies of the FCC regulation and several legal precedents where courts had sided with homeowners against HOAs in similar disputes. I also contacted my attorney, Marcus Chen, who specialized in property law. Marcus assured me that I was on solid legal ground and advised me to document everything related to the dispute. 2 days later, I received a certified letter from the Sagaro Heights HOA. The letter, written on official letterhead and signed by Brenda Patterson, informed me that I was in violation of Section 7.3 of the Community Covenants regarding exterior modifications. It demanded that I remove the satellite dish within 7 days or face daily fines starting at $100 per day. The letter also threatened legal action if I failed to comply. I immediately responded with my own certified letter, citing the OTARD rule and including copies of the FCC regulation. I explained that federal law preempted the HOA's covenant restrictions, and that any attempt to fine me or take legal action would itself be a violation of federal law. I also requested that the HOA board review the matter with their legal counsel before proceeding further. The following Monday, my doorbell rang again. This time, when I opened the door, I found 2 police officers standing on my doorstep. My heart rate immediately accelerated. The older officer, whose name tag read Officer Rodriguez, gave me a polite nod. "Mr. Emerson," he asked. "Yes, that is me. Is there a problem, officers?" Officer Rodriguez glanced at his partner, then back at me. "We received a complaint from your HOA president about an illegal structure on your property. She claims you have installed equipment without proper permits and that you are operating some kind of unauthorized telecommunications facility." I felt a surge of anger at Brenda's escalation tactics. "Officers, please come in. I can explain everything." I led them through my house to the back patio where we could see the satellite dish mounted on the rear slope of my roof. That is the equipment in question. It is a standard consumer satellite internet dish, 18 inches in diameter. I use it as a backup internet connection for my work-from-home business. Officer Rodriguez looked at the dish, then at his partner. "That is just a regular satellite dish, like for TV or internet." "Exactly," I said. "The HOA president is upset because I did not get their permission before installing it, but federal law specifically protects my right to have this equipment. It is covered by the FCC's over-the-air reception devices rule." I had anticipated this confrontation and had prepared a folder with all my documentation. I showed the officers copies of the FCC regulation, my letter to the HOA, and the HOA's response. Officer Rodriguez read through the materials while his partner examined the satellite dish more closely. "Mr. Emerson," Officer Rodriguez said after a few minutes, This appears to be a civil matter between you and your HOA. There is no criminal activity here. You have not violated any building codes or city ordinances. This is not a police matter." "I appreciate you coming out to verify that," I said. "I am concerned that the HOA president is wasting city resources by making false reports." The younger officer spoke up for the first time. "We will note in our report that there is no violation and that this is a civil HOA dispute. If she calls again about this same issue, we will inform her that it does not warrant police involvement." After the officers left, I called Marcus Chen again. He was furious when I told him that Brenda had called the police. "That is harassment," he said. "She is trying to intimidate you into compliance by involving law enforcement. Make sure you document this incident. If this continues to escalate, we may need to consider filing a complaint against the HOA for harassment." That evening, I attended the monthly HOA board meeting. The meetings were held in the community clubhouse, a Spanish-style building near the neighborhood entrance. About 30 residents were present, seated in folding chairs facing a long table where the 5 board members sat. Brenda was in the center seat, flanked by the vice president, treasurer, secretary, and a member at large. I had not planned to speak at the meeting, but when Brenda opened the floor for new business, she immediately launched into a tirade about my satellite dish. "We have a resident who has decided that our community standards do not apply to him," she announced, looking directly at me. "Mr. Emerson has installed an unsightly satellite dish without permission, and he refuses to remove it despite repeated warnings from the board." I raised my hand. "I would like to respond to that." Brenda glared at me. "You will have your turn to speak when I am finished." "No," I said, standing up. "You are making false statements about me in a public meeting, and I have the right to defend myself. What you are not telling everyone is that my satellite dish is protected by federal law. The FCC's OTARD rule prohibits HOAs from restricting satellite dishes that are used for internet or television reception. I have provided you with documentation of this law, and I have also informed you that your attempts to fine me are illegal." Several residents turned to look at Brenda, whose face had gone red again. "That is your interpretation of the law," she said. "Our attorney has advised us that our covenants are enforceable." "Then your attorney is wrong," I said. "And if you proceed with fining me or taking legal action, I will file a complaint with the FCC, and I will countersue the HOA for harassment and violation of federal law." An older man in the front row raised his hand. "I have a question for the board. If what Mr. Emerson is saying is true, and there is a federal law that protects his right to have this dish, why are we wasting association resources fighting him on this?" Brenda's lips pressed into a thin line. "Because we have to maintain standards in this community. If we let one person break the rules, then everyone will start doing whatever they want. But it is not breaking the rules if it is protected by federal law," another resident chimed in. The meeting devolved into a heated debate, with some residents siding with me and others supporting Brenda's position. Eventually, the board voted to table the discussion pending further legal review. I left the meeting feeling slightly vindicated but still frustrated by the entire situation. Over the next 2 weeks, life returned to a somewhat normal rhythm. My primary internet connection had been repaired, but I was grateful to have the backup satellite system in place. I continued working from home, managing projects for clients across multiple time zones, and the satellite dish sat quietly on my roof, causing no problems for anyone. Then, on a Thursday morning, I received another certified letter from the HOA. This one informed me that the board had reviewed the matter with their legal counsel, and had determined that their covenants were valid and enforceable. The letter stated that fines would begin accumulating starting the following Monday at a rate of $100 per day. The letter also informed me that if the fines remained unpaid, the HOA could place a lien on my property. I immediately forwarded the letter to Marcus Chen. He called me back within an hour. "Yannick, this is beyond ridiculous. They are either getting terrible legal advice, or they are deliberately ignoring the law. I think it is time to file a complaint with the FCC and prepare for litigation. This HOA is violating federal law, and they need to be stopped before they try this with other homeowners." "Let us do it," I said. "I am tired of being bullied." Marcus helped me prepare a formal complaint to the FCC's Enforcement Bureau. The complaint detailed the HOA's attempts to make me remove my satellite dish, their threats of fines and legal action, and their refusal to acknowledge the odd rule, despite being provided with documentation. We included copies of all correspondence, photos of the dish installation, and statements from the police officers who had responded to Brenda's false complaint. The FCC complaint process was not instant, but Marcus assured me that the Commission took these violations seriously. In the meantime, Monday arrived, and according to the HOA's letter, fines were supposed to start accumulating. I received an invoice in my mailbox that afternoon, billing me for $100 for that day's violation. I did not pay the invoice. Instead, I sent another certified letter to the HOA board, this time informing them that I had filed a formal complaint with the FCC, and that their continued attempts to fine me were violations of federal law that could result in penalties against the HOA and potentially against the individual board members. That letter must have struck a nerve because 2 days later, Brenda showed up at my door again, this time with another board member, a man named Gerald Hutchins who served as the HOA treasurer. Gerald was in his late 60s, with gray hair and a perpetually worried expression. "Mr. Emerson," Brenda said when I opened the door, "we need to discuss this situation before it gets further out of hand." "I agree," I said. "Would you like to come in?" They followed me into my living room and we sat down in the seating area. Brenda sat stiffly on the edge of my couch, while Gerald looked like he wished he were anywhere else. "We received your letter about the FCC complaint," Brenda began. "Gerald here thinks we should reconsider our position on your satellite dish." Gerald cleared his throat. "I've done some additional research on this odd rule you mentioned, and it does appear that the federal regulation is quite clear. I am concerned that we are exposing the association to significant legal liability by continuing to pursue this matter." "Then why are you here?" I asked. Brenda leaned forward. "We are willing to offer you a compromise. If you move the satellite dish to a less visible location, perhaps on the side of your house instead of the roof, we will drop the fines and withdraw our objections." I shook my head. "No. First, the dish needs to be mounted on the roof to have a clear line of sight to the satellites. Moving it would compromise its functionality, which is exactly the kind of impairment that the odd rule prohibits. Second, I should not have to compromise on my legal rights because the HOA does not like how it looks. The law is clear and I am not doing anything wrong." Brenda's expression hardened. "You are being unreasonable." "No," I said firmly. "You are the one being unreasonable. You were informed about federal law, you chose to ignore it, and now you are facing the consequences. If you drop this matter immediately, acknowledge in writing that my satellite dish is legal, and refund any fines you have attempted to charge me, then I might consider not pursuing further action against the HOA. But I am not moving my dish, and I am not accepting any restrictions on my federally protected rights." Gerald looked at Brenda. I think we should take this back to the board and recommend that we drop the matter. Brenda stood up abruptly. Fine, but do not think this is over, Mr. Emerson. There are other ways to make life difficult for residents who do not want to be team players. That statement, which sounded very much like a threat, proved to be prophetic. Over the next few weeks, I began receiving violation notices for increasingly petty issues. My trash cans, which I brought back from the curb within hours of pickup, were supposedly left out too long. My front lawn, which was professionally maintained by the same service used by half the neighborhood, allegedly had weeds that violated community standards. My house numbers, which had been installed by the previous owner and had been there for years, were supposedly not the correct font style according to the architectural guidelines. I documented everything. I took photos with timestamps. I saved every letter and email. And I forwarded everything to Marcus Chen, who was building a case for harassment. Then Brenda made her biggest mistake. She called the Federal Communications Commission and filed a false report claiming that my satellite internet system was causing radio interference with emergency services communications. This was a serious allegation, and the FCC took it seriously enough to send an inspector to my property. The inspector, a man named David Kowalski who worked for the FCC's Enforcement Bureau, arrived on a Wednesday morning with a van full of monitoring equipment. I had received advance notice of his visit, and I had taken the day off from work to be present. Mr. Emerson, David said after introducing himself, we received a complaint that your satellite internet installation is causing interference with public safety radio frequencies. I need to inspect your equipment and take some measurements. Absolutely, I said. I am happy to cooperate fully, but I should tell you that I believe this complaint is false and was filed as retaliation by my HOA president. David nodded. I have actually reviewed your complaint file about the OTARD violation, so I am aware of the ongoing dispute. Regardless, I still need to investigate any interference complaints. Can you show me your installation? I took him up to the roof and showed him the satellite dish and the associated equipment. David spent about an hour taking measurements with various instruments, checking frequencies, and inspecting the installation. He also tested the ground wire and examined the coaxial cable runs. Finally, he climbed down from the roof and packed up his equipment. Mr. Emerson, your installation is completely clean. There is zero interference being generated by your equipment. In fact, your installation is professionally done and meets all safety standards. The complaint that was filed is completely baseless. Can I ask who filed the complaint? I said, even though I already knew the answer. David consulted his tablet. A Brenda Patterson, who identified herself as the president of your homeowners association. She claimed to have received multiple reports of interference with police and fire radio communications. Did you contact the local emergency services to verify those reports? I asked. We did. Scottsdale Police and Fire both confirmed that they have had zero reports of radio interference in this area. In fact, the fire department captain I spoke with said that the type of satellite internet system you have cannot physically interfere with their radio frequencies because they operate on completely different parts of the spectrum. I felt a cold anger settling in my chest. So Brenda filed a false report with a federal agency. David looked uncomfortable. I cannot speak to her motivations, but I will be filing a report that indicates the complaint was unfounded and that no interference exists. If you want to pursue this further, you could potentially file a complaint about the false report, but that would be a separate matter. After David left, I called Marcus Chen and told him what had happened. Marcus was silent for a long moment after I finished. Yannick, filing a false report with the FCC is a serious matter. It is a federal offense. This woman has now crossed a line from being an annoying HOA president to potentially committing a crime. What do? I asked. We document this, and we add it to your FCC complaint. We also need to consider whether this rises to the level of filing a police report for harassment. Let me do some research and get back to you. That evening, I received an email from Brenda. The subject line read, "Final warning," and the message informed me that the board had voted to begin legal proceedings to place a lien on my property for unpaid fines, which had now supposedly accumulated to over $3,000. I forwarded the email to Marcus, who called me immediately. "This is it. They are forcing our hand. I am filing a federal lawsuit tomorrow morning. We are going to sue the HOA, the board, and Brenda Patterson personally for violating federal law, for harassment, and for abuse of process. I am also going to request an emergency temporary restraining order to prevent them from placing any lien on your property." "Do it," I said. The next morning, Marcus filed a comprehensive lawsuit in federal court. The complaint named the Saguaro Heights Homeowners Association, the 5 board members, and Brenda Patterson individually as defendants. It alleged violations of the FCC's OTARD rule, harassment, abuse of process, and sought damages as well as injunctive relief. The lawsuit hit the neighborhood like a bomb. Within hours of the filing, my phone started ringing with calls from other residents. Some were supportive, thanking me for standing up to the HOA. Others were critical, accusing me of causing unnecessary conflict. A few told me that they had also had problems with Brenda's heavy-handed enforcement of HOA rules, and were glad someone was finally pushing back. The federal court granted our emergency motion for a temporary restraining order, prohibiting the HOA from placing any lien on my property, or taking any enforcement action related to my satellite dish, pending resolution of the lawsuit. 3 days after the lawsuit was filed, I received a call from an attorney named Jennifer Blackstone, who identified herself as the HOA's legal counsel. "Mr. Emerson, I have been retained to handle the lawsuit you filed against my clients. I would like to discuss the possibility of settling this matter without further litigation." "I am listening," I said. "After reviewing the facts of your case and the applicable federal law, I have advised the HOA board that they are not in a strong legal position. The OTARD rule is clear, and your satellite dish installation appears to be protected. I would like to propose a settlement where the HOA acknowledges that your dish is legal, drops all fines and violation notices, and agrees not to take any further action regarding the dish. In exchange, you would agree to dismiss the lawsuit." "What about the false report to the FCC?" I asked. There was a pause. "That is a separate matter. The board was not aware that Miss Patterson had filed that report, and they do not condone that action. Miss Patterson has actually resigned from the board as of this morning. That was news to me. She resigned." "Yes." "When the board learned about the false FCC report and reviewed all of the violation notices she had been sending you for minor issues, they determined that she had exceeded her authority and had exposed the association to significant legal liability. They asked for her resignation, and she provided it. I thought about the offer. Part of me wanted to push forward with the lawsuit to make sure that Brenda and the HOA faced real consequences for their actions. But another part of me was tired of the conflict and just wanted to move on with my life. "I need to discuss this with my attorney," I said, "but I want more than just an acknowledgement that my dish is legal." I want a written policy change that ensures no other homeowner will face this kind of harassment for installing equipment protected by the Othard rule. I want a formal apology from the board, and I want the HOA to reimburse my legal fees. Jennifer agreed to present those terms to the board. Over the next week, there was a series of negotiations between Jennifer and Marcus. The final settlement agreement included the following terms. The HOA would officially amend its covenants to acknowledge that any equipment protected by the Othard rule was exempt from architectural review requirements. The board would issue a formal written apology to me and post it in the monthly newsletter. The HOA would pay my attorney fees, which totaled just over $8,000. All fines and violation notices against me would be withdrawn and expunged from my record. And the HOA would send a letter to all residents explaining the Othard rule and their rights to install protected devices. Marcus advised me to accept the settlement. "You have accomplished everything you set out to do," he said. "You have vindicated your rights. You have forced the HOA to change its policies, and you have gotten compensation for your legal fees. Most importantly, you have made it clear that the HOA cannot bully residents into giving up their federal rights." I agreed to the settlement, and the lawsuit was dismissed with prejudice, meaning it could not be refiled. The judge signed off on the agreement and it became a binding court order, but the story did not end there. About 2 weeks after the settlement was finalized, I received a call from David Kowalski, the FCC inspector who had visited my property. "Mr. Emerson, I wanted to let you know that the FCC has completed its investigation into your complaints about the HOA's Othard violations. We are issuing a formal warning to the Sagaro Heights HOA and requiring them to undergo training on federal communications law. We are also investigating the false interference report that was filed." "What happens with that investigation?" I asked. "That is still ongoing," David said. "Filing a false report with the FCC can result in civil penalties and, in egregious cases, criminal referral. Ms. Patterson will have an opportunity to respond to the allegations, but I can tell you that the evidence is pretty clear that she made false statements to a federal agency." Over the following months, I learned through the neighborhood grapevine what happened to Brenda Patterson. The FCC had issued her a formal notice of apparent liability, which was essentially a citation for the false report. She was given the option to either pay a substantial fine or contest the citation at a hearing. She chose to pay the fine, which I heard was somewhere in the neighborhood of $10,000. She also moved out of Sagaro Heights about 4 months after the settlement, selling her house and relocating to a different part of Scottsdale. The HOA board was completely reorganized. Gerald Hutchins became the interim president, and he immediately implemented a series of reforms to prevent the kind of overreach that Brenda had engaged in. The board adopted a new policy requiring all violation notices to be reviewed by legal counsel before being sent to residents. They also established a formal appeals process for residents who disagreed with HOA decisions. As for me, life gradually returned to normal. My satellite internet backup system continued to function perfectly, automatically taking over whenever my primary connection hiccuped. It had proven its worth numerous times, allowing me to maintain seamless service for my clients regardless of any issues with the fiber optic line. I became somewhat of a minor celebrity in the neighborhood, known as the guy who had stood up to the HOA and won. Several other residents approached me over the months that followed, asking for advice on their own disputes with the association. I always gave them the same advice: know your rights, document everything, and do not be afraid to stand up for yourself when you are in the right. One particularly satisfying moment came about 6 months after the settlement, when I attended an HOA meeting to vote on new board members. Gerald Hutchins, who had done a good job as interim president, was running for a full term. During his campaign speech, he specifically mentioned the changes the board had made to respect federal law and homeowner rights. "We learned an important lesson this year," Gerald said to the assembled residents. "An HOA exists to serve the community and maintain property values, not to exercise arbitrary power over residents. We have to operate within the law, including federal regulations that protect homeowner rights. I am committed to leading an HOA that is fair, reasonable, and respectful of everyone's legal rights." Gerald was elected by a wide margin. The other board positions were filled by residents who shared his philosophy of reasonable governance. The era of Brenda Patterson's authoritarian rule was officially over. I also used my experience to help other homeowners beyond my own community. I wrote a detailed blog post about the Othard rule and my experience fighting the HOA, which was picked up by several homeowner rights websites and forums. I received emails from people all over the country who were facing similar situations with their own HOAs. I always directed them to the FCC's website and recommended they consult with an attorney, but I was gratified to know that my experience was helping others understand and assert their rights. The irony of the entire situation was not lost on me. Brenda had been so focused on maintaining what she saw as community standards and aesthetic harmony that she had been willing to ignore federal law and harass a resident. In the end, her actions had cost the HOA thousands of dollars in legal fees, had resulted in her own resignation and a substantial federal fine, and had actually resulted in stronger protections for homeowners installing satellite dishes and other protected devices. About a year after the whole incident began, I was sitting in my backyard on a Saturday afternoon, enjoying the Arizona sunshine and working on my laptop via my primary internet connection. My satellite dish sat quietly on my roof, barely visible from the ground, ready to take over at a moment's notice if needed. My phone rang and I saw it was Marcus Chen calling. "Hey Marcus," I answered. "What is up?" "I wanted to give you some closure on the Brenda Patterson situation," he said. "I just heard from a colleague who has connections at the FCC. Apparently, the investigation into her false report is finally closed. In addition to the fine she already paid, she has been barred from filing any future complaints with the FCC without first having them verified by a licensed engineer. It is a pretty rare sanction, but the FCC felt it was necessary given that she had knowingly made false statements about interference with emergency services." "Wow," I said. "They really took it seriously." "They did. Filing false reports about interference with emergency services is not something they take lightly. If she had not paid the fine and accepted the sanctions, they were prepared to refer the case to the Department of Justice for criminal prosecution." After I hung up with Marcus, I sat for a while thinking about everything that had happened. The whole ordeal had been stressful and time-consuming, but I was glad I had stood my ground. The principle at stake had been important, not just for me but for every homeowner who might face similar overreach from an HOA in the future. I thought about how easily I could have just given in to Brenda's initial demand and removed the satellite dish. It would have been the path of least resistance, but it also would have meant giving up my legal rights and allowing the HOA to violate federal law. More importantly, it would have set a precedent that the HOA could ignore the law whenever it suited them, which would have had implications for every other resident in the community. Standing up for my rights had not been easy, and there had been moments when I questioned whether it was worth the stress and expense. But looking back, I knew I had made the right decision. Federal communications law exists for good reasons. The Odd Rule was created because Congress recognized that access to information services like satellite internet and television is important, and that HOAs should not be able to interfere with that access based on aesthetic preferences. My backup internet system had literally paid for itself multiple times over in the year since I installed it. There had been at least a dozen occasions when my primary fiber connection had gone down due to construction accidents, equipment failures, or network maintenance. Each time, my satellite backup had kicked in within seconds, allowing me to continue working without interruption. For a consultant whose income depends on being available to clients around the world at all hours, that reliability was invaluable. The following month, I was invited to speak at a homeowner rights conference in Phoenix. The conference was organized by a nonprofit that advocated for homeowner rights and provided education about dealing with HOAs. I was nervous about public speaking, but I felt it was important to share my story. Standing in front of about 200 people in a hotel conference room, I told them about my experience with Brenda Patterson and the Saguaro Heights HOA. I explained the Odd Rule and how it protected homeowners' rights to install satellite dishes and other reception devices. I talked about the importance of knowing your rights, documenting everything, and being willing to stand up to illegal HOA demands. During the question and answer session afterward, a woman in her 50s raised her hand. How did you have the courage to fight back? I am in a similar situation with my HOA, but I am afraid that if I push back, they will make my life miserable. I thought carefully about my answer. I understand that fear, and it is legitimate. HOAs can make life difficult if they want to. But here is what I learned. Bullies rely on people being too afraid to stand up to them. Brenda Patterson assumed I would just comply with her illegal demands because most people do not want the hassle of fighting. But when I stood my ground and showed her that I knew my rights and was willing to defend them, and when I made it clear that continuing to violate federal law would have real consequences for the HOA, and for her personally, she eventually backed down. Not before causing a lot of trouble, but she did back down. And in the end, the HOA had to change its policies, and she lost her position and faced federal sanctions. Another man asked, "What advice would you give to someone who is just installing a satellite dish or antenna and wants to avoid problems with their HOA?" "First, do your research," I said. Understand the Odd Rule and make sure your installation qualifies for protection. The dish needs to be 1 meter or less in diameter, and it needs to be installed on property you own or have exclusive use of. Second, even though you are not required to get HOA permission, I would recommend informing the HOA about your installation and providing them with information about the Odd Rule. Do it in writing, so you have documentation. That way, if they do object, you have already established that you know your rights. Third, install the device properly and safely. Make sure it is professionally installed if you are not confident doing it yourself. And finally, be prepared to stand your ground if the HOA does object. Have the FCC regulations printed out. Consider consulting with an attorney, and do not let them intimidate you into giving up your legal rights. After the conference, several people came up to thank me for sharing my story. One man told me that he had been planning to cancel his satellite internet service because his HOA had threatened him with fines. But after hearing my presentation, he was going to fight back instead. A woman told me that her HOA had been trying to make her remove her amateur radio antenna, and she now understood that she had federal protection under the same rule. Driving home from Phoenix that evening, I felt a sense of satisfaction that I had not expected. What had started as a frustrating conflict with an overreaching HOA president had turned into an opportunity to help others understand and defend their rights. Life in Scottsdale Heights continued to improve under the new board leadership. Gerald Hutchins proved to be a fair and reasonable president, focused on maintaining property values and community amenities without micromanaging residents' lives. The board started holding regular open forums where residents could voice concerns and ask questions. They published clear, easy-to-understand guidelines about HOA rules and enforcement procedures, and they made sure that any enforcement actions were consistent, fair, and legally sound. I even found myself volunteering for one of the HOA committees, the Communications and Technology Committee, which had been established to advise the board on issues related to internet service, cable TV, and other technology infrastructure in the neighborhood. It was a bit ironic, given my conflict with the previous board, but I felt it was important to contribute to the community and to help ensure that other residents would not face the kind of problems I had experienced. About 18 months after my initial confrontation with Brenda, I was working in my home office on a Tuesday afternoon when I heard a knock at my door. It was a gentle knock this time, not the aggressive pounding that Brenda had favored. When I opened the door, I found a woman in her early 30s standing on my doorstep. She looked nervous. "Mr. Emerson?" she asked. "Yes, that is me. Can I help you?" "My name is Rachel Morrison. I just moved into the neighborhood last month over on Desert Willow Drive. I am a real estate photographer and I work from home just like you do. I need to install a satellite internet backup system like yours, and my realtor told me I should talk to you first because you had some kind of issue with the HOA about it." I smiled. "Come on in. Let me tell you a story." I spent the next hour telling Rachel about my experience with Brenda Patterson, the odd rule, and how I had successfully defended my right to have the satellite dish. I showed her the documentation I had kept, including the FCC regulations, my correspondence with the HOA, and the final settlement agreement. I gave her Marcus Chen's contact information in case she needed legal advice. "The good news is that you should not have any problems," I told her. "The HOA has changed its policies, and they now recognize that devices protected by the odd rule are exempt from architectural review. But I still recommend that you inform them in writing about your installation and cite the federal regulation, just to have documentation." Rachel looked relieved. "Thank you so much. I was really worried about this. I cannot afford to lose clients because of internet outages, but I also did not want to start off on the wrong foot with the HOA." "You will be fine," I assured her, "and if you do have any problems, let me know." "But I really do not think you will. The current board is very different from the previous one." Rachel was right to be cautious, but her installation went smoothly. She sent a courtesy letter to the HOA informing them of her plans, and she received a response from Gerald Hutchins acknowledging her letter and confirming that her satellite dish was protected by federal law and did not require architectural review. It was exactly the kind of reasonable, professional response that an HOA should provide. Over the next few years, several more residents in Scottsdale Heights installed satellite internet systems, satellite TV dishes, and even a few amateur radio antennas, all without any problems from the HOA. The community had learned its lesson about respecting federal law and homeowner rights. As for Brenda Patterson, I never saw her again after she moved out of the neighborhood. I occasionally wondered what had become of her, whether she had learned anything from the experience, or whether she was causing problems in some other community. I hoped for the sake of her new neighbors that she had learned to be more reasonable and respectful of other people's rights, but somehow I doubted it. Some people never change. My satellite internet system continued to serve me faithfully, automatically taking over whenever my primary connection failed and ensuring that I never missed a deadline or lost a client due to connectivity issues. Every time I glanced up at that little 18-inch dish on my roof, I felt a small sense of pride. It represented more than just backup internet access. It represented the principle that individuals have rights that cannot be arbitrarily taken away, even by organizations that claim to act in the name of community standards or property values. The experience taught me several important lessons. First, that knowing your rights is essential. If I had not researched the odd rule before installing my satellite dish, I might have been intimidated into compliance when Brenda first confronted me. Second, that documentation is crucial. By keeping detailed records of every interaction, every letter, and every incident, I had been able to build a strong case that ultimately forced the HOA to back down. Third, that standing up for your rights often benefits others, not just yourself. By fighting back against the HOA's illegal demands, I had helped change their policies in a way that protected every other resident in the community. And finally, I learned that federal law exists for good reasons, and that it is important to defend those laws when they are violated. The odd rule was not just some obscure technical regulation. It represented a congressional determination that access to communications services is important enough to warrant protection from local restrictions. By enforcing that rule, I had not only protected my own interests, but had also upheld an important principle of federal communications policy. Years later, when I eventually sold my house in Saguaro Heights and moved to a different part of Arizona, one of the first things I did in my new home was install a satellite internet backup system. And this time, before I even started the installation, I sent a letter to my new HOA informing them of my plans and citing the odd rule. I received a polite response acknowledging my letter and confirming that no architectural review was required. It was gratifying to see how much smoother the process could be when an HOA actually understood and respected federal law. Looking back on the whole experience, I would not say I was glad it happened, because it was stressful and time-consuming, and I would have preferred to avoid the conflict entirely. But I was glad that, when I was confronted with an illegal demand from an overreaching HOA official, I had the knowledge and the courage to stand my ground. And I was especially glad that my experience had helped other homeowners understand their rights and defend themselves against similar overreach. The satellite dish that caused so much controversy was just a small piece of technology. 18 inches of metal and electronics designed to receive signals from satellites orbiting thousands of miles above the Earth. But it had become a symbol of something much larger: the right of individuals to make reasonable use of their own property, the importance of federal protections for access to communications services, and the principle that HOAs must operate within the law, not above it. In the end, federal communications law had protected me, just as it was designed to do, and justice had been served.